All right. Hi, everybody. Joining me is Katherine Loftus, WBZ's legal analyst, in what could be our final Friday podcast on Karen Reed's retrial. Hi, Katherine.
Hi, we made
We
it.
made it. We made it to closing arguments. I'm sure you've been talking about this. It's Friday, June 13th, day of closing arguments in this case. I'm sure you've been talking about it all day, so I'm going to make you repeat yourself.
That's
But
okay.
give me your early takeaways from closings. I mean, and especially compared to last year.
I mean, I think they both did a really good job. The level of lawyering is very high in this case. It's interesting to watch, two completely different styles. Alan Jackson is very, sort of showman, his voice is loud, and but in Brennan, on the other hand, is a little more reserved. But he has some personality. It's just not quite as outgoing. But I found both of them to be pretty persuasive, and really that's what the job of a defense attorney, a trial attorney is closing argument is really, like your bread and butter, where you wrap up everything that you need to make sure that the jury knows. And so I think that, it was different in the sense that from last year that we have a different attorney for the Commonwealth. Obviously, Alan Jackson did it last year. There was a slight shift from like the full-blown third party that they argued in the first trial. There was still quite a bit of third party, finger pointing despite the rulings from the court yesterday. But it was more focused, I think, this time on Bowden, Michael Proctor, where the police didn't go as opposed to where they did. But overall, I thought they both did very well.
Okay, so let's get into the defense a little bit because you mentioned it. The I was and wasn't surprised to hear Alan Jackson say, he said basically Brian Higgins, he said coaxed John to the
Yeah.
house and that John went and he specifically said the garage or the basement, which it's not surprising because we have heard these allegations multiple times outside of court from the
Right.
defense team. But that was not a part of this trial to my memory.
No, and the difficult part about this is that I mean there was clearly stuff argued in the defense closing argument that was not in evidence, and I think impermissible based on what the court's order was about. Judge Canoni specifically asked in the charging conference of David Yannetti, you're not intending to point the finger at Brian Higgins, correct? You're just saying that, oh, he couldn't have been in, could have been a possibility, but you didn't investigate him, which is that was this distinction that they want to try to draw between exclusively third party argument and Bowden third party. And so Bowden, the third party argument that you're able to submit to the jury is essentially, hey, there were these text messages, there was other things going on, you saw somebody at the bar. Could that possibly have been another avenue to explore? And you didn't, therefore the standard, the police investigation is substandard, or omitted that or whatnot. Instead, really, I think it probably went beyond that a little bit. But ultimately, some of the very best trial attorneys, I mean, they do push the line and they do go over because realistically, what is the judge going to do? Declare a mistrial? I mean, she could have given a curative instruction. And I was wondering while Alan Jackson was closing, whether Brennan was going to, or if he was just going to let it go and then kind of try to address it in his closing himself, which I think that's what he did. Probably better because he doesn't want to be the one delaying the jury anymore between, closing arguments. So it was interesting.
It was definitely interesting. And I mean, like, this is the opportunity for both sides to basically, it's their only chance to tell the jury a story, right?
That's right. That's right. And the the Commonwealth has to tell a story as well. It's not that they don't, but the Commonwealth is a little bit more constrained because they're the government. They're the one bringing the charges. They can't sort of over exaggerate what the evidence is. Defense counsel is a little bit different. Your job as a defense attorney is to zealously advocate on behalf of, your client. And, I think both of them, there were very different stories about what allegedly happened on January 29th, but they both were very persuasive in their own ways. I think you're on mute.
You're coming outside
Okay.
with me here in Dedham. I'm still outside the courthouse, and you're coming outside because this is part of this case at this stage. It happened last time too. um, all of these media and supporters show up and the internet goes away. So
Of course.
I'm taking a walk to get a better signal. So that's why you're joining me. This is some real live reporting. There you go. Okay. So my other question for you about the defenses, it's a thought and a question. And I was wondering, because you watch on the stream, and I was
Right.
wondering if you could even see this. I'm not sure the camera showed it. The PowerPoint presentation that
Hmm.
the defense was presenting was virtual note cards. And they would have a
Yes.
statement on them,
Yes.
like Brian Higgins went to Canton Police or something like that.
Right.
Or Arca says the crash didn't happen. And what would happen is that note card would then fade into a screen that was a big collage of note cards with the
Right.
title Reasonable Doubt.
Right.
So you have talked about this knocking bricks out of the Commonwealth's wall, and that's reasonable doubt. Um, what do you think of that visual representation of the defense's burden?
I mean, I think it's helpful anytime there's a visual for anything, it helps the jury. And even something as, is fairly simplistic, but sometimes that's all you need is just sort of this like basic rudimentary showing of what we want the jury to understand. And, the Commonwealth is going to get up and they're gonna tell you all these things and sort of keep these cards in mind when you hear what the Commonwealth says. Well, there's questions about this, there's questions about, Higgins and the Sally Port, there's questions about Michael Proctor, there's questions about Brian Albert in the house, there's questions about the dog. And I think probably the most telling from the defense's argument really went to, he said fairly, or Alan Jackson said fairly early on, you can maybe think someone did it, but you have to be, morally certain. It has to be proof beyond a reasonable doubt. So he sort of presented this option to the jury that you could be leaning towards potentially my client did it, but we have enough problems here with the case that you can't possibly cross that threshold. So what he's trying to say is, the Commonwealth built this wall all the way up theoretically, and we might not have knocked the whole wall out, but I think we've knocked enough out with what we've shown you here. And that sort of visual representation of of the little cards on, I think it was helpful. I mean, I think, listen, everybody loves the visual aid. And when it's
Right.
broken down in a way that is, easily discernible for the viewer, hey, I think it's a good idea.
All right, let's talk about the Commonwealth's closing arguments. We've talked a lot about their theory of the case when they've laid it out in a way that's digestible, when they haven't. This time it really was uh that Karen Reed chose, in their words, chose to put her car in reverse, knowing that that could kill John, did it, drove away, realized what she had done, and didn't get him any help. Um, and they used a lot of car and cell phone data to try and prove that. So I guess my question for you is, what do you think was the strength of Hank Brennan's closing argument, and what do you think is maybe the Commonwealth's, like, what's their biggest challenge for this jury?
Well, I think the strength is that, you know, the strength is the evidence, the physical evidence, the itself. So we're talking about, the taillight pieces at the scene, the shoe up against the curb, the hat, the straw, um, the microscopic pieces of taillight in his sweater. That's really the strength of the Commonwealth's case. And then tied into what the data is. This trial, it was a little bit different than the first because it was not quite as clear, like what was the Commonwealth alleging the data actually shows. This trial, we saw Hank Brennan, particularly in closing, really line everything up, talking about the battery temperature, how many steps John took, at what time his phone stopped moving, when it started moving and warming up again in the morning when he was found. So I think really the physical evidence is in the data is most of the Commonwealth's, strength. Um, and I think they ultimately have problems. It depends on, because they can't say specifically, this is where John was hit at this exact space, at this exact, part of his arm, and this is exactly how he landed. I do think that there are some jurors who want that, sort of final piece to the puzzle that they might get to third base, but they're unsure about how they get home. They played the video. It was really interesting. I mean, fascinating that they played the video from the defense expert showing that the arm could break a taillight. So the question becomes to jurors is that do you actually need to know specifically how it happened, or can you take all of the pieces together and come to the place where nothing else could possibly have happened, but she hit John O'Keefe? So, I think he did a good job at presenting sort of the timeline and the data of what he has to support that.
And it really did kind of come down to like, okay, do you believe that version or do you believe what Alan Jackson says, which is that all of that data is wrong and there's no way it happened?
That's right. I mean, we've been talking about it for a while, but I do think it comes down to, I think the deciding factor for the jurors is, do you credit the evidence at the scene, right? Do you credit the taillight pieces? Do you credit the shoe? All that kind of stuff. If you do, then your next question is, okay, well then how did it all get there, right? If the vehicle didn't hit John O'Keefe, then how did everything else end up in that circumstance? But if you believe it's likely to be planted, or even the possibility that it's planted, you don't even make that evaluation. So you're going right to a not guilty. So I think it comes down to whether the jury as a whole will credit the physical evidence on the scene or not.
Okay, before we go, let's take a couple minutes on some. This is so ironic for this day. I just got the low battery notification on my computer.
Of course.
So let's talk about a little bit of criminal procedure for a minute.
Yep.
Some things people are curious about on the internet and also that are being argued in court. Let's talk about jury alternate selection, the way jurors are picked. So today the judge picked the foreman and she picked him first, and he's the juror in seat number 1. He's a black man in, my guess is his 40s. I can't say for sure. And then after that, alternates were drawn. And so ultimately we ended up with 7 women and 5 men on the deliberating jury. There's been a lot of talk, including a motion by the defense for better transparency during the alternate drawing selection. Is there weight to this?
I don't think so. I mean, there's no, listen, there's a standard in courts, right? And the reason why they promulgate these standards, we have rules committees that are made up of judges and lawyers that say, okay, we are going to go by sort of a set routine, so that each court, ultimately the judges in the trial court have a lot of discretion, but we're going to follow the standard practice. So just like the jury instructions that were read to the jury today, those are standard, written by the rules committee. They're the same thing. The judge just doesn't like create her own jury instructions. Same thing with picking the alternates. I mean, this is the way it goes. And I think if there had been any substantiated allegations that there was some sort of misconduct or wrongdoing in selecting the alternates in the prior trial, potentially this could be a valid issue. But to just essentially state that, we want to deviate from the norm because we want to deviate from the norm, I'm not sure there's a significant enough argument there to warrant that ruling.
Yeah, the defense had actually asked for Karen Reed to be able to pull the numbers out of the bingo box.
I mean, it would have been for some good TV shots, but
right, but that was a big ask. No, I mean,
if I'm being totally honest, I don't. That seems sort of an outrageous ask from my perspective. Why would we have the defendant, in any other case? But I do think, is it fair that, the way they do it is sort of in the bingo wheel and they pull it out, and they wanted it shown a little bit more. And it's not that the most of their requests were unreasonable. It's just not that substantial of a deviation from the norm. And if there isn't a basis to warrant it, the judge is usually just going to go with what the standard is.
okay, I'm gonna do something risky and share my screen for a second. If I
Okay.
know how to do this. Do I know how to do this? Share. Share this. Okay. Can you see this?
Yes, I can see this.
Okay. And you can see this.
Yes.
This is the second verdict slip just for the second charge, manslaughter. There's a lot of words on it. Okay, manslaughter while OUI. Yeah. Now I'm gonna stop sharing. This happened during the last trial as well. The defense takes issue with that jury form. They say it's too confusing, and they want, because it's manslaughter while OUI, and then if they don't convict Karen Reed of that, the jury, there's lesser options.
Right.
The defense wants a not guilty option added to every single lesser option instead of the one at the top that says not guilty on any of these charges,
Right.
basically.
Right.
The judge said no because there's no case law to support this. I mean, this is like so nerdy, but people are interested. So explain it for us.
I mean, unfortunately, there's not that like fancy or special of an explanation outside of, these are again, standard forms with everything. So the standard way to pick the alternates, it's set by statute. The four-person gets picked by the judge, and then, the alternates are drawn. Standard jury instructions, standard jury forms. And, we did hear from the jurors last time. I think what's interesting is they talked about the difficulty that they weren't sure whether they could return the entire verdict if they had decided as some as the others. But I don't know if there was any specific allegations about confusions about the form itself. So I think without any support, there was some discussion in court when, she said, Judge Canoni said, where's the case law for? And he said, well, we don't have any yet, implying, we could make case law here. But I don't know if there was a substantial enough basis for it. I mean, her jury instructions the first time, kind of the entire way she presented the case to the jury, went through quite literally every single appellate court possible, all the way up to the United States Supreme Court, and she's been affirmed at every level. So without case law to support why she should change it, I don't know that she had a reason to do so.
Yeah, and I will say I had spoken to some jurors anonymously, and they had explained to me that the confusion was that A, they didn't understand the possibility of rendering a split verdict, and
Right.
B, they didn't understand that coming forward and telling the judge we're hung or we're deadlocked would lead to a mistrial. Like they didn't know the consequences of saying
Right.
that.
And that was my understanding, that it was more, they were more confused about, how they were actually supposed to report it as opposed to what the actual slip looked like. So,
Yes. Okay. I think that's all we have the time for today. I don't know if we'll be back next Friday, but we'll have full days Monday, Tuesday, Wednesday, unless there's a
what
verdict beforehand.
what do we think? What do we think? I think
I'm
probably
I'm
I'm
going
thinking
Tuesday afternoon.
we're on the
You
same
too?
page. Yep.
Okay, I asked you this a couple days ago, Crystal Ball. Do you have a prediction now of the outcome?
I think it's the same. I think probably the highest chance is a mistrial. I think there's a lesser chance of a conviction on a manslaughter. And I think the lowest likelihood is an acquittal across the board. I think she'll definitely be acquitted on the murder too and the leaving the scene. I'm not sure that she'll be acquitted on the manslaughter. So I think I'm sticking with my prediction.
Okay. And your prediction, your
We'll
first
see.
prediction is mistrial again. Oh,
I know, I know, I know. It's just difficult because, even the way we look at what happened today, the closing arguments, and people have such different views and it's difficult to know if that's just the online world, if that's really representative of what the jury's thinking. So we'll see.
we'll see. Okay, well, thank you as always, and
Thank
have a great
you.
night. See you
Yeah,
later.
you too.
Bye.
Bye.